Tell me when. All set. Thanks. I'd like to call a special meeting, Narragansett Planning Board to order Thursday, June 1st, 2023. Mr. Friday. Here. Mr. Brady. Here. Dr. O'Neill.
Yep.
Mr. Fleming, I'm here. Mr. Brunetto is absent with cause. We have one item on the agenda tonight, a recommendation to the Town Council zoning text amendment, Section 2.2, add definition of quote-unquote college student, and Section 7, add new subsection regulating student-occupied dwellings. I'd like a quick summary from Mr. DeLuca and or Mr. Marcella if he wants to weigh in. And then I had planned to go to the public, but it's there's no one here. Well, sorry, Mr. Lynch. I didn't mean that you were no one. Well, I don't expect counselors to talk, but they can, I guess. But anyhow, Mr. DeLuca.
Briefly, and very briefly, I've got the text of the proposed ordinance is up on the screen. It is very similar to the ordinance that was drafted in 2020. What is changed is, first of all, the definition of college student is not changed. It's the same definition that was proposed 3 years ago. An individual enrolled as an undergraduate or graduate student at any university or college educational institution. The second part is somewhat changed. So it's a proposed new section of the zoning ordinance, section 7.21, would be inserted in the zoning ordinance as a new subsection. And it has some language change. It starts out as, it used to just say student-occupied dwellings as the header. Now it says student-occupied dwellings located in R10, R10A, or R20 zone. So what this is telling us is this particular new section, if approved, section 7.21, will apply to only the R10, R10A, and R20 zones. The R40, the R80, and anywhere that residential development is existing as legal nonconforming would not come under this regulation. And the regulation is that a dwelling or dwelling unit shall not be occupied by more than 3 college students unless the building in which the dwelling is located is owner occupied. And the only change from the 2020 definition, excuse me, the 2020 standard is the header. The description that I just read off is not changed at all. Just the header restricting the application to those 3 zones.
Okay.
That's it in a nutshell.
Yep.
I could go on into my staff report, which you've got, but I'll leave that to you.
No, we've discussed, we're going to wait.
Q&A.
We're going to wait till we get to the decision on that,
Yep.
to go through that. There's no reason to do that at this point. Okay. Does anyone on the board have any questions about this? Joe?
Could you explain why are we restricting this to particular zones? I mean, if you got R40 or R80, and you have 6 or 8 young people in there having a good time, why are we limiting us to the smaller?
Well, I believe the intention here is to somewhat emulate what the city of Providence did. And if you were to look in my staff report, I give you a copy of what the city of Providence did.
But they don't have R40 and 80. They can't. I mean,
well,
their houses are right next to each other. I mean, we're a little different place. Go ahead. I'm sorry.
They restricted it to R1A and R1 districts, which are high-density districts in the city. Point being that those are the areas, the high-density areas, and R10 and R20 are the higher-density areas in Narragansett, where houses are closer together. I mean, that just makes sense, right? And if they're closer together and people are acting a little bit loud, having crowds in their backyard or on their sun deck, the sound travels and it can affect a greater number of properties because of the proximity of properties in the higher density zones. So I believe what we're doing here through this draft is trying to emulate the city of Providence by making certain that we are not applying it town-wide, but only applying it where the most significant potential impact would be located, again, in the higher density zone areas. And remember that all of this is under the context of reminding ourselves that the Rhode Island State Supreme Court upheld the Providence ordinance and spoke in their decision about it not being applied to the full city, but only applied to neighborhoods that were most highly or potentially highly affected. That's the logic.
Okay.
That may be your logic, but I don't agree with it. The more specific you get like that, I can't believe somebody in our 40 zone who's got, you know, a bunch of young unruly people in there. I mean, where I live, a lot of the properties are 80, but many of them are 40. And, you know, if my neighbor, you know, had rented that out to a whole bunch of students, I mean, it'd be like they're in my living room. I mean, I realize that, you know, 5,000 square feet and 10,000 is a lot smaller than 20,000, 40,000, and 80,000, but I just think it ought to cover everybody. I mean, why?
Well, that's
Why
part
we
of
do
what
this?
we'll decide. You know, that's part of what our recommendation will be, up or down on this, you know? If we all agree that shouldn't be, then we'll tell the council, we don't agree with specific zones.
But if I don't know if Steve has advised you that this is the only way this is going to get through somewhere through in the legal system, then I think we ought to know that. But
I'll allow Steve to respond to that.
Obviously, Doc, there's certainly no guarantees. However, what we did was, we did follow, and especially the Providence case closely. We looked at the fact on where their zones were and the reasoning behind essentially limiting their zones to the R10, to the R1 and R1A zones. That, in addition to other factors, we thought, legally, we thought that an ordinance that was more focused, especially almost like our FAR ordinance. Our FAR ordinance is focused toward the smaller lots, smaller houses, more densely compact neighborhoods, as opposed to, again, if you're on an 80,000 square foot lot, FAR doesn't apply to you. That's one of, again, the similar thinking with this, based upon the guidance of the Providence case, and obviously looking at where students, there will be outliers everywhere. You could have someone renting on Ocean Road to many students if they wish. However, the majority of the neighborhoods that do rent to students, the majority of the noise complaints, all of those type of complaints are all in an 90% are in R10 and R20 zones. Our R10A is only Narragansett Avenue.
Yeah, it's not much
That's
R10A.
that's not much at all, and we have boarding houses on there. So that's the thinking behind it. However, this is, you know, just our initial thinking. You guys certainly can
Yeah,
look at the report and weigh everything, and then, you know, send whatever recommendation you wish to the council.
Anybody else?
I have two questions.
here you go, buddy.
Go ahead.
I have two questions. Should there be, and this is my ignorance more than anything else, but should there be a legal expectation of the consequences to the owners, realtors, and students in violation of this defined within the statute or within the ordinance?
What do you mean?
I mean, we have this down that says, okay, you can only have 3 students. But in it, it doesn't, it's like, so what? I mean, if this is passed, nothing says what happens. And is that legally, you know, a legal expectation that if you pass something like this, that you would also spell out, if you violate this, this is what happens?
So in other words, right now, if on any zoning ordinance, we have our zoning ordinance, if something does, if you do violate a zoning ordinance for whatever reason, you have a 2-family and an illegal 2-family, we'll just call it an illegal 2-family. The zoning ordinance doesn't spell out the zoning ordinance does spell out a fine. However, all that is litigated through municipal court.
Right.
Municipal court, and the judge, depending on the violation, has the right, if the city proves its case, or the town proves its case, has the right to, either give someone the right to cure, or up to, in our ordinance, $500 a day fine. So the penalty is in, the initial penalty is in the zoning ordinance, however, it's enforced through municipal
I
court.
understand that, but we don't even have anything defined in this as far as an initial penalty.
It is not a separate fine. The way this is written, it's not a separate fine. It's a similar fine as to
Oh, okay.
any other zoning ordinance.
I assumed that, but I didn't want to jump
Yeah,
out of
correct.
that.
So if you, again, if, I'll use the two-family. If you had, today, if you had an illegal two-family in a one-family zone and you went to municipal court, that would be governed, the same way with this ordinance.
Okay.
Any fines would be enforced that way.
And the assumption of how the ordinance will be enforced is also within that same scope, right? It goes through,
It would go, well, if someone is
Same due
issued
process.
the building official would issue a violation, the owner has two avenues. They can go to municipal court and fight it there. They can they can appeal the determination of the building official and go there. If they lose there, then it goes to municipal court, and then it works its way up.
okay. Thanks.
Can I continue that thought process?
Yeah, sure, Joe.
Yeah, I brought this up in the past. So we have enough personnel on the payroll to enforce this now. My understanding was we did not.
We do, the building official has personnel on staff that implement the minimum housing requirements of the town in general. And this is now well, if it's implemented, this becomes another one of the housing requirements or the zoning requirements of the town. And they do actually monitor the neighborhoods, the neighborhoods that are most well-known for having a high density of seasonal rentals. They go out and actually drive around. And also they would be notified of any phone calls sent to the town, the police department. If the police were called to a particular location, they'd be notified after the fact and go in and deal with it, deal with whatever housing or zoning violations might have occurred. So they do have staff that do that kind of work.
The last time that we walked this road, we had a wonderful suggestion that if we have roughly 2,000 rentals that are registered, I don't know how many we have that are not registered, but in any case, 2,000 that are registered, and our registration fee is X. I've forgotten what number, because that was years ago when we walked this road before. And the suggestion was, I thought was excellent, is that's one of the lowest fees in the whole state. Why don't you raise the fee so you can have a real solid enforcement, rather than trying to I mean, the building department, I'm sure, has its usual standard amount of work and personnel demands, but here's an opportunity. If we're going to do this, my colleague here, you have to enforce it somehow consistently and fairly across the board. Otherwise, it's like it just gets everybody all stirred up. And we don't.
Excuse me, he has beefed up at least a half-time, if not a full position, since we first visited this.
Yeah.
Right? At least Juan Ice met with the building inspector, and he's got more resources. Go ahead, Joe.
But speaking as a taxpayer, why don't we have the people who have to be inspected pay the load? I mean, it just semes to me.
Yeah, the fee has been.
We have an opportunity here, so.
Yeah, the rental registration fee has been a point of discussion in-house, not only as it relates to this particular ordinance, but as it relates to short-term rentals. And short-term rentals is a broader description. It also speaks to the summer seasonal rentals, not just the 3-student component. So it has been a point of discussion in-house. We being staff, have tried to quantify what would be an appropriate fee, and even if there should be different categories than what we have today. Nothing's been resolved as yet, but it is definitely on the table for further discussion.
Interestingly, Mike, or guys, the three of the four major points that we laid out in 2020 have to some degree been implemented relative to this. One is beefing up by the police department of resources for enforcement. Another one's beefing up of the building inspector's department, even though it might not be enough, it's still more. And the other was bulk zoning.
Right.
So even though when we rejected the student ordinance before, we had offered some other suggestions, and three of those at some point are either in fully or in, have made progress, so.
Yeah, agreed.
So-
I think we have made strides in the last 3 years.
Mark, did you have another?
Yeah, I'm sorry. I wasn't sure if we were going to get into this discussion tonight or at our next meeting, but I did have a couple of logistical ones, going back in this same realm. And these are kind of sister. Do occupants, if the police come out or the building inspector staff come out, do the students what compels a student to identify themselves actually as a student? And are residents of rentals registered with the town at the time, so that there is a cross-check to be able to go out and say, okay, you three people live here, who are you other two guys? And is there any ramification for false disclosure? Yeah, no, I'm not a student, and then I guess you are, but, I mean, that was one of my questions, and the whole idea of, well, he's just a visitor, so.
So a couple of things. One, I guess that there were a few questions.
And part of this is because I wasn't here when this was first.
No, understood, and
So
that's
I'm-
the whole purpose of
I'm
this.
regurgitating old history,
No,
and I apologize.
And there is no legal obligation for an occupant of a house to speak to an official who knocks on the door. That's a simple fact.
Right.
To answer that question, it would obviously be up to the building official or the town to be able to determine the status of the occupant.
So Steve, whether it's an unrelated situation or a student situation, the burden's on the town to prove that there's a violation relative to whatever one's being applied.
Ultimately, however, laws are enacted, and the whole point of enacting laws is for 99% of the people to follow the laws.
Absolutely, totally agree.
Not to try to circumvent
Totally
the laws by not answering the door.
I know.
So, we're not
No, it's
looking-
true.
No, I agree, but this smells of, of the people that obey the rules will obey the rules, and those that don't are going to look for
But you
ways
could say
around.
that with it.
And
Yeah, you can say that
I
about
agree.
anything.
I
And we have to find ways to enforce, whether we agree with the number or however we come out
Yeah,
with
this
this.
conversation is totally
You
separate
still,
from that.
you
I'm
still
just
have
trying
to
figure
find a
out-
way to enforce.
Yeah, I'm just trying to understand if this is implemented in any way, shape, or form.
Correct. Yeah,
how do you
ultimately, it's
enforce
up
it?
to.
Because if not, you just got something on the books to say, well, we got something on the
So
books.
just to get it on the table, the corollary to that is, in the case of unrelated, just to take two here, and I'll get to the student, in the case unrelated, the landlord is not obligated to prove that they are related, correct? It's, if there's a suspected violation.
Yeah, so that's currently in litigation. I'm not going to.
Okay. Then, in the case of the student, the obligation is on the town to prove that they are students,
Ultimately.
which obtaining that information may be difficult.
That I can't answer.
Yeah, I think it may be. So, I'm not sure what can be enforced, but that's okay.
Well, unless you implement a registration program.
Well, but still, I don't know. Rupert, did you have anything? No, you're okay. Okay, maybe I will go to the public, get some commentary, and then we can come back and see what our next step. So we're going to go to the public. As always, this is not a formal public hearing. We're not taking sworn testimony. We're going to limit everybody who wants to speak to 3 minutes. And if you want to speak, you need to be recognized by the chair, and then I'll be keeping track of the time. Thought we'd have a lot more people here, but this is what we have, and we'll go from there. Does anyone wish to speak on this issue? Ma'am? You want to come up? Sure. You don't? Okay. Sure, come on up. And just identify yourself, please.
Charlene Riley Paskowski. I live on Cove Road in Narragansett. And I have a rental at the end of my street. I contacted, found out that indeed we do have a person who, Larry Ellman, who I guess is monitoring.
Larry's a new employee in the building inspection's office.
I sent an email to him saying at the end of my street. I sent an email to Larry saying I had a rental at the end of my street that's listed for tax purposes as a 3-bedroom. In actuality, it's a 5-bedroom. And it's renting out to at least 6 kids. And they're basically fine. The problem comes in the summertime when it's VBRO, and we end up with a multitude of people in and out, and people on vacation, they're not watching their kids, running out into the street, yada, yada. My concern is, first of all, why aren't they being taxed as a 5-bedroom? I was told we have no jurisdiction over that. We go by square footage. And then he referred me to the, I guess the building inspector. No, it wasn't the building inspector, it was Christine Beck.
It's clerk's office.
Pardon me?
No? This is Christine Beck.
Ms. Beck is the tax collector.
Oh, tax collector.
Oh, and she responded, they had no jurisdiction. I'm like, who has jurisdiction? I mean, there's 5 bedrooms there, being taxed as 3, with a multitude of people living there. That does not seem right to me. I don't know what the laws are in Narragansett pertaining to this, but
Okay, ma'am, how it's taxed is a different issue from what we're hearing tonight.
I understand
We're
that.
hearing the 3 students, so if you
I
want to
understand
keep
that.
your comments to that, if you could.
I
Fine.
can give a brief response.
Brief, yeah, brief.
It starts with a complaint. What you need to do is a formal complaint through the building official's office. He's the zoning enforcement officer. So if you were to say, I believe this property is being improperly used, and they do not have, their bedrooms are not legal, then he has to go in and inspect based on the complaint. He doesn't just go knock on doors. He does need to respond to a formal complaint. Then, if there is a violation of some sort, then they would be issued a notice of violation, and that would bring them into this room on another night when the municipal court is here. If it's not resolved, well, it could be resolved in one of many different ways. Being cited and having to, request approval of the 4th and 5th bedroom, or removal, or something else. So I don't take part in municipal court, so I can't really give any detail on that. But a lot of what is enforced under the zoning ordinance is based on complaints. We do not have, even though we have more staff than we had only a few years ago, we don't have the kind of staff available to just go out and check things out.
it was my understanding that inside of their door, they had to have a list of renters. I think that's something that needs to be looked into. So if the police come knocking on the door, who are the first 3? Because I have another house in my neighborhood on Castle where a rape took place. I happened to call it in because I heard the poor girl. The owner was sued, and the first 3 students on the rental agreement were sued. So there's a lot that can happen with the rentals. Most of the time, they don't cause a problem. It's the summer people that cause the problem. But yet, something needs to be done to monitor it more closely. And I don't know if this man, Larry Edelman, is going to be out driving around and checking to see who's there. We had state police at the end of my street one Sunday morning.
Wrap up your comments, please.
Okay, fine. Done.
Thank you. Anyone else? Yes, sir.
Hi, my name is Kevin McKenna, and I live at 31 Pleasant Avenue in Narragansett. I'm here tonight to voice my support for the 3 college student ordinance. 44 years ago, my wife and I purchased a home in a beautiful residential neighborhood named Eastwood Look. We loved this area because we could easily walk down to the beach, Black Point, even Salt Pond. It was also close to the Scarborough Beach area, where our families had resided for years. At that time, the area was mainly comprised of families that lived in their homes on a year-round basis. Eastwood Look was a close-knit community where neighborhood children attended local schools and participated in town-sponsored sporting leagues. Residents knew their neighbors, and we watched out for each other. 13 years ago, my wife and I moved away from our home in Eastwood Look. We had lived in this home for more than 30 years. We raised our family in this home and experienced a lifetime of beautiful memories in this home. However, over the years, this beautiful family neighborhood had evolved into an off-site URI dormitory location. In 1979, when we first moved into Eastwood Look, there were approximately 25% rental homes on our street. In 2010, when we moved away from Eastwood Look, there were approximately 80 to 85% rental units on our street, Summit Road. The typical home housed at least 4 students and 4 cars. Traffic was heavy when students commuted to classes and increased during the weekend when students gathered together to socialize. It was not uncommon to have large parties that had to be quieted down by the police. By 2010, I no longer knew the names of many of our neighbors, and I never knew what type of party might be staged during the upcoming weekend.
Mr. McKenna, about a minute more, please.
What's that?
About a minute more.
Okay, great. The 3 college student ordinance will decrease noise, traffic, and pollution caused by cars commuting to the campus. Furthermore, it will decrease water and sewage usage in Narragansett. Lastly, it will improve the quality of life for year-round residents who are being squeezed out of their neighborhoods by landlords more concerned with profits than residential family life. Please vote for the 3 college student ordinance and protect the quality of life in our neighborhoods throughout Narragansett. Thank you.
Thank you. Appreciate it. Anyone else?
Ben, you're not going to speak? Jeez.
Yes, sir. If you identify yourself and give us your comments in a 3-minute period, I appreciate it.
Yes, Harry Schofield, 9 Atlantic. I just want to echo my support for Kevin's comments. I think he basically hit it on the head. You know, I read the staff report briefly a little while ago and its coverage of some of the rationale for the last decision and when this was before the planning board. And I think some of those decisions were based on, you know, data that was, you know, wrong, such as the number of, you know, rentals, way underestimated. And there was also a reference to the fact that, you know, the amount of color, the, you know, orange stickers, they're way down, police surveillance is better, which is all true. But the three-student ordinance, it was never aimed at big parties and, you know, orange stickers. As Kevin said, it's just the aggregate density in neighborhoods. You know, these are all family homes. They were built that way. And we all know that even despite the fact that the, you know, the foreign related ordinance is legit, landlords are ignoring it. They're putting 5, 6, and, you know, 7 kids in these houses. Complete disregard for the neighbors. And, you know, we know the school population's down. We know the residential population's down. So it seems to me that this time around, you really need to take a look at the facts as they are. You know, it's not the occasional wild party three-student ordinance is designed to prevent. It's just a reasonable neighborhood balance. Number of people in a house the house was designed for, you know, parking for a number of cars you'd expect from a family, and so on and so forth. 5 and 6 people in a house, doors slamming, you know, late night noises, arrivals, goings and coming. This is not people because they're partying, it's just the daily life of too many people in one place. So I hope you take those considerations into account this time around. It's just a case of balance, not a case of anti-student. It's not a case of trying to push the student renters out. That's not going to happen. It's just we need a balance. And the three-student ordinance, as has been shown in Providence, it's a good approach to it. Thank you.
Thank you. Anyone else?
There we go.
Yes, sir. Identify yourself, please. I'll start the clock when you're ready.
So Dennis Lynch, 22 Central Street. So I think some of the initial questions about implementation and enforcement are important, but I think they do come after the fact, after you and the town council put in the three-student. And we will not get it right the first time. The enforcement and the implementation, it will not be perfect, and there will need to be tweaks, and there'll need to be fine-tuning. And I think that, you know, to echo something that Harry said, that we really want the landlords front and center. This is not about the students, you know, against the wall, you know, spotlight on them, are you or are you not? We really need the investors, the people that are making the profits from these respective units to be held accountable, probably in the rental registration form, where, you know, you attest to the following. You are renting to students, you are not renting to students, because those are the boys and girls that are, you know, are really making the money and are investing in our town and not necessarily residing there. The word disruption was used in the report in terms of the disruptive nature of students. And again, yes, it's not about parties so much as sort of the tearing of the fabric of the neighborhoods. And I think that's why the smaller zones do make more sense. It's not, yes, you still could have a wild party on an R40 or an R80, but you won't have, as one resident told me, when I moved in, there were 13 houses on the street, no rentals, and now there's 4 rentals and some soon to be 5. And we simply need to put a cap on this. We don't even know it. People guess between 6,000, 8,000 students in town. We'll always have thousands and thousands of students. We know how to coexist with them, but we can't take too many more. You can't have too many more to tip upside down the residential quality here. So I really urge you to put this in. It won't be perfect the first time. Anyone who's watched the 6 hours so far of the appeals on the 4 unrelated understand this is a trail of tears, but I think this is a cleaner and more direct and definable way of getting at occupancy limits. I would end by saying I would like to leave for the record and for the board, if many of you might already have it, some are new and might not have, the consultant report that was filed in the last lawsuit from a third party that described how a three-student is consistent and does comport with the comprehensive plan. I think that many, many sightings in there of the specific places where this is conforming. And I think that's a worthwhile document, and I hope if I can leave it here.
Do you
that
have
it can be
copies of that,
distributed.
Mr.
I
Lynch?
do.
Yeah, just give it to Mr. DeLuca, and we'll put it as part of the record.
Okay. Thank you very much.
Thank you very much.
Thank you, Dennis.
Anyone else? No one here. Mr. Indalia would like to speak. You could identify yourself, and you have 3 minutes, Mr. Indalia?
Certainly. May it please this honorable board, staff in particular, council. My name is Vincent Indalia. I am a resident at 25 Baker Road in Narragansett, Rhode Island. I also happen to practice as an attorney, and I don't speak at the moment, but I do have clients who wished to have me voice some of their concerns. They are current residents who are college students under your defined bill. One is 4 people, 2 gay couples who are unmarried, so they are all 4 unrelated. Obviously, they believe this is an attempt at a protected class of individuals that our Rhode Island Supreme Court and the United States Supreme Court has indicated as a protected class, and its attempt to, of all days, the first day of Lesbian, Gay, Bi Rights Month, an attempt to prohibit college students who are gay from assembling. The law that was approved in Providence that this town now tries to mimic, you have to remember that the zone that it affected was a contiguous zone of less than 2 square miles, and it centered around Providence College. And it was identified solely for single-family residences where there were multiple families living in them. There was a zoning-specific purpose for creating that law that had a rational basis. I would also point out that when that case was argued by Federal Hill Capital LLC, they probably violated Lincoln's primary law, which is somebody who is an attorney should never have themselves as a client because they are both fools and a client. He said it better than I did, but you get the point. And in that case, what was addressed to the Supreme Court when Justice Flaherty wrote his decision was the fact that they argued that it affected the due process clauses of equal protection for college students under the Rhode Island Constitution only. Justice Flaherty found that college students under the Rhode Island Constitution were not a protected class. What he didn't argue and was never put before the Rhode Island Supreme Court is what Justice Harlan Marshall of the United States Supreme Court has noted, which is that under the First Amendment to the United States Constitution, every member living in this country has a right to freely associate. And they have a right to freely associate for legitimate purposes. And a legitimate purpose to associate is for college students, as you have defined them in your proposed ordinance, is often to advance political speech, political ideas, scientific ideas, and collaboration. This ordinance would infringe upon that right.
About a minute more, Mr. Indalia.
In addition, you have other steps you have to take, and I know that somebody has just handed up something they believe identifies a legitimate basis under the town comprehensive plan that this ordinance would support, but as I've indicated to this board membership as a body, not the individuals themselves, because you all didn't sit here when I voiced the opinion previously, the gem of marine biology sits at the north end of your town. The gem of the state's institutions, which now has one of the finest pharmacy schools and engineering schools in the state of Rhode Island and certainly within New England. We recognize it as one of our major employers, and we recognize that we ought to, as a community in the state, embrace the college students as defined in your statute and otherwise. If you go to any other state, go to State College in Pennsylvania or any of the other large schools, they embrace those students and they work with the students, and the town and municipality services work with them.
Wrap up,
So-
Mr. Daly.
I would urge you to not be so microcosmic in saying 3 students alone. I can tell you you'll get an immediate challenge from my clients. I'll find others of color and creed and race who want to freely assemble to advance educational purposes. It'll be an entirely new argument.
Okay. Thank you, sir. Anyone else? No one else is speaking. Okay. We had anticipated a long public discourse tonight, and we have some time set aside, if we have to, for a decision on June 20th at the regular planning board meeting. We also have a placeholder for June 28th if we need it, because we have to, upon advice from Mr. Marcello, we have to deliver a decision to town council by the end of June. So what I had anticipated is a night full of commentary from the public, and then probably to continue it to the next meeting and make a decision and a recommendation to the council, if not the 28th. So I'm not sure where to go here. We can continue discussion about items if the board has any questions. I'm not prepared to move to a decision. I'd still want to think about it, even though we didn't have the commentary. And the public should know that we received 4 letters today, which is another point I want to ask Mr. Marcella. Generally, when we have these kind of meetings, we make it known, and it's very beneficial to the board that people can submit their thoughts in writing. Would they still be able, between now and our next meeting, to submit those thoughts?
Correct. My advice would be twofold. One is, given as you said, kind of how many people have shown up tonight, that we continue it to the 20th, because for you guys to make a decision. That'll give staff time to write it up and get it to the town council. The 28th only gives us 2 days. So that's my first advice. Secondly, if you want to keep it open also, to want to allow anyone else watching tonight to submit anything in writing, you certainly can do that and encourage any people in town to submit anything to the board, and certainly staff can distribute it to all of you and put it, in the file.
So that's good.
As we normally do.
People watching on YouTube can submit something. People here can tell people to submit something.
Correct.
Rest assured, the board will read all that. We always do. And in fact, I think people, I've said many times, I think people organize their thoughts better in writing and make a more persuasive case, either on one side of the issue or the other. And we're happy to receive that communication. We actually look forward to it. So we'll keep the hearing open for the purposes of that, so we can receive that. We do have a placeholder on the 20th. We have to decide the rest of the agenda because it's our regular meeting, and I'll be in discussion with Mr. DeLuca and Ms. Sabo on that. So that's, and I don't want to tell you, I don't want to make a decision if everybody else does tonight, but I'm not, it doesn't appear that people are ready to.
Two people
to
to
make
your
the-
right here, I don't know about the fellow at the end there, but who don't want to make a decision either.
I need to think about it, and I do want to receive commentary from people, because when I got 4 communications today, I said, okay, here we go. This is going to be like last time, when this room was full, and it's not like last time. But hopefully we'll get more commentary on both sides of the issue, and we'll make a decision, hopefully make a decision next time. I think the points And folks, remember, I've been reminded many times, what's before us is what's before us, and that's what we have to rule on. So it's a 3-student ordinance. We'll go up or down on that on a recommendation to the council. That's not to say that commentary can't be made by the planning board, and it should be made in conjunction with that. If anybody on the board has concerns about things or wishes the council to be communicated about other things that they should consider, that's all well and good, secondarily to the actual recommendation of the specific ordinance. We're not here to make a recommendation on the unrelated or to make anything on the student that's not what we've been presented with, right, Steve? It's up or down, and then we can make commentary for the council to consider. Correct. Okay. Yeah, Mr. Brady.
Procedural, should I submit these as evidence, stamp these? Necessary,
Yeah,
unnecessary?
those are emails. I think they're already in the,
Yeah, these are
The
all
emails are in the record.
yeah, in the record.
Yeah, just wanted to make sure.
Did we enter the stuff Mr. Lynch submitted?
I did. I
Okay.
have that all stamped.
So that's part of the
Ready to
record.
go.
Joe?
Yeah, since we obviously have a little time, why aren't we saying, I have nothing against students, I was a student for 25 years, you know? So, I was. So,
That was a long time ago, though, Joe.
no, that's for sure. But why are, not that I'm in favor of the picking on students, obviously, that's why I'm bringing this up. Student/unrelated, why aren't we using that? You at least I'm missing it. To cover the summer folks, you know? The people from Jersey.
Yeah, it's a very good and logical question, Doctor. The town could go in that direction if we wanted to go in that direction. I believe a lot of the tenor of this ordinance is somewhat dictated by what we saw successfully implemented in the city of Providence. As you know, our unrelated regulation doesn't dovetail with the 3-student regulation. That is dictates 4. And as Ms. Marcello mentioned, there's litigation ongoing. So that's up in the air. Could we, if we dialed this back 3 years, could we have just put those two thoughts together and tried to write one ordinance? Maybe.
Well,
I don't know.
Mike, we discussed that at length last time in 2020.
Right. Yeah, you did actually make some
And in our
recommendations.
staff findings, in our recommendation, I think the board unanimously said the student ordinance is redundant with the unrelated, but there's still the 3 and the 4. And now we've introduced another differentiator between the student and the unrelated. And so this is all coming, and it come out in our conversation next time. This is all coming to my concerns about this as it bumps up. And remember, we have to make consistency with zoning and consistency with the comp plan arguments on this matter. And I know the 4 unrelateds in litigation, but can I say anything about the 4 unrelated, Steve? As an ordinance?
You can say anything you want. I just can't answer you.
That's a dangerous thing to tell me.
But I'm not going to answer you, but you can say anything you want.
So, just a little bit of a history lesson, and maybe if I lay it out quickly, then people can refute it or acknowledge it so that we know. And actually, we have someone in the audience tonight that probably was knee-deep in this thing back in 2016. But, so the town, and stop me where I'm wrong, the town had a 3-student ordinance, a 3 unrelated ordinance on the books prior to 2000, sometime. That was thrown out by Judge Fortunato, right? And so it was null and void for whatever reason. Subsequent to that, 34 cities and towns, approximately out of the 39, have an unrelated ordinance in. In addition, in 2016, the town council convened an ad hoc committee, and the ad hoc committee recommended to us a 4 unrelated. My recollection, and I think we had a member of the ad hoc committee here, my recollection was the ad hoc committee may have at the time wanted to come back with the 3, but they were advised by counsel that the 4 might be an easier path to get by the courts. So it wasn't necessarily that they wanted 4 as opposed to 3. It just seemed more expedient. I could have that wrong. I don't know, Mr. Schofield, if you know that or can comment on that. Sure, go ahead. I just for the history books, I'd like to remember what it was.
Yes, no, you're correct. When I did chair that committee, subcommittee,
Right.
and it was right after that huge riot in Eastwood Look, and the committee was formed, and we did look at 3. Most of the people on my committee, it was a small committee, wanted 3, and many wanted students. We were told at the time that students was off the table. We were told that, and I think it was, correct me if I'm wrong, I think it was Dawson that was the solicitor at that time.
Going back a ways.
Yeah, I believe that's who it was. He said, just don't go there. I won't support it. And so I took that back to the committee, and I mean, actually, what became kind of the salesman for the 4 unrelateds, because it became clear to me in discussing, I mean, it took, maybe 6 or 7 months or 8 months to develop the report that we submitted, and I remember presenting our conclusions and recommendations to you folks at the time.
Right.
You people did approve that, and again, before presenting it to the town council at the time, I went back to the solicitor, and because I was getting pushback on 4, and his comments at the time were that, because I researched it enough to realize that subsequent to the DeStefano decision, I believe the town made some changes to the ordinance to separate things like rooming houses and boarding houses. There was some confusion there, but it was still 3, and you know, Dawson said that was a technicality that most people wouldn't appreciate it, that people know 4 is different than 3. One of the town council members at the time told me point blank they would not support 4. And I told Dawson at the time, I simply, after all this work, I did not want to get up in front of the town council and make a recommendation only to have the town council look at the solicitor and him say, no, that's not going to fly. So I simply got Dawson's buy-in before presenting it to the town council. So that's the reason it's 4 instead of 3.
There was some discussion about 3, but
Yes, there was much discussion about
legal
it.
counsel led it
Legal counsel
to a certain place.
Yes, he said he would have difficulty supporting 3. One town council member said she was vehemently against 3.
Right.
Would support 4, and the reason it was unrelated is because the solicitor was specific that, you know, don't go there. So again, it was some pushback from members of the committee, and I finally asked them, look, it's you know, this or nothing. I didn't want to. It had to be so anyway, that's how it came about. That's the background. Thank you.
Thank you. And that's the history. And then this board debated that extensively, and I believe we made a favorable recommendation to the council on a 3-2 vote. I believe that I was the decider. I waited till the end. I think we were split 2-2. I voted for it for a lot of reasons that I articulated, one of which I thought the ad hoc committee did a lot of work, did a tremendous amount of research, and that this is what they came up with, and I thought it was worth setting a bar. It makes sense to set a bar. I think Mr. Lynch, or someone said, you know, when people are presented with a rule or a regulation or a standard, the majority of people try to follow that. I believe that. I may be naive, but I believe that most people try to follow the rules. So it was important for me to set a bar, to set a number, because I thought neighborhoods were being disturbed. Since that time, though, this whole student thing has always been a problem for me because it's been divergent from the 4 unrelated. I never understood why we couldn't prosecute the students under the unrelated. I understand why it was 3. So we still have to have that discussion. But the history of this is that the 4 went in because the 3 had been thrown out of court, and legal counsel advised the ad hoc committee and the council to put in 4 unrelated. So that's why the 4 unrelated sitting there now. There's no magic to the numbers, even though people will tell you if it's 3, we're going to get more houses for families, and if it's 3, we're going to get less houses. It depends what your side of the argument you take. I haven't seen any studies that would conclusively point it either way. I know people have opinions about that, but anyhow. So we're faced with yeah, Mark?
Yeah, just, again, a historical question. Why was the 3 thrown out? I did some
Judge
research, I couldn't
Fortunato,
find
I think it's, you said DeStefano, but wasn't it Fortunato was the judge? What, Vin? Fortunato,
I
yeah.
looked at, I couldn't find the reason.
But I also think that his decision was fairly repudiated in the Providence Supreme Court decision. So, I mean, I think we sit here saying, I don't think Fortunato's negating of that 3 would stand up anymore, particularly since 34 cities and towns have an unrelated. So,
I was just going to fill in a point. The case was DeStefano versus Axton.
oh, okay. The case
Ruled
was
on by
DeStefano.
Judge Fortunato.
Okay. So I think that's old news, really, I think, from everybody's perspective. And I guess Fortunato got not eviscerated, but criticized by the Supreme Court on that. Anyhow, but we're sitting here with the 4 unrelated, and we're presented with the 3 student, with now the wrinkle of certain zones. So that's what we have to try to reconcile at the next session. Joe?
Just a point. Is it 4 unrelated, any zone?
Yes.
4 unrelated law apply
Yes.
to any zone?
It applies townwide. Yeah.
Okay, thank you.
So under this proposed ordinance, in an R40, hypothetically, Joe raised the point, 10 students could be in a house. They could potentially be prosecuted under the unrelated ordinance, but they can't be prosecuted under the student ordinance as it's proposed.
It's a zoning violation. It's not a criminal prosecution.
Okay. I'm sorry, I used the wrong term.
Correct. There would be a zoning violation for the
There
property.
could be a zoning violation under the unrelated,
Correct.
but not under the student, if it was an R40 zone. I would like to make one other point. People made the point, I think Mr. Lynch, Mr. Schofield, maybe somebody, maybe Mr. McKenna also. And I thought we would have people here, because we have in the past, just go on and on about the wild parties. But I think my position has always been the 3 or 4, whatever, unrelated student, whatever that is, does nothing for the September, May, 200, 300, 400 people's parties. It's not meant to address those. I mean, back in my day, you could have 200 people by just putting a word out for a few days, sitting in the student union and telling people to come to your house for a party, and you'd have a couple hundred people. Today, with social media, I mean, it's ridiculous. You put an Instagram, Twitter post. So you can get those kind of numbers, whether somebody lives by themselves in a house or with one other roommate. So the 3 or 4 number isn't going to address. That's an issue, in my view, my opinion, for the police department to crack down on those, however they do tickets, stopping the party buses from going into Eastwood, whatever the measures that they have to do, because I don't think the 3 or 4 has anything to do with the wild parties. The 3 or 4, the unrelated, and the reason I voted for unrelated is because it's the day-to-day disruption of the neighborhood by overcrowding. And if you set a bar, if you set the number, then at least you're working towards mitigating that day-to-day disruption with parking and noise and music and drinking and trash and all that impacts these neighborhoods. But again, my view is students and summer renters. And we're going to get into discussion of the comp plan and what's consistent and what kind of language supports it. But I just wanted to get that point about parties out of the way, because I don't think this ordinance has any impact on the big end of the year parties or the September parties. So, anybody else have anything? So I guess we're gonna, Mr. Indalia? Can you come up? Because you're on YouTube, Mr. Indalia, whether you know it or not.
Well, there you go. I just wanted to make sure I understood your procedure at this point in time. You've had a public hearing. No, you've had a hearing that was put on the agenda to discuss this. You have a potential opening several weeks from now for the same exact item to be discussed again. Is it, and you have a relatively small crowd, as you indicated, is it that you're closing this meeting and you're going to come back and discuss it amongst the board members and vote, or you're going to allow more public comment on a future date that you'll identify now and put on the agenda for that future date?
Well, it's a volatile situation, as they say. So first of all, we're leaving it open because I think people need to submit things in writing. The fact that we leave it open, I think we have to take commentary at the next meeting, correct? Anyone who's spoken tonight, I don't think they need to speak again. They voiced their opposition or support to the ordinance. But if there's new information identified between now and then, people have to be given an opportunity to comment on that. I'll keep it to the 3 minutes. That's why when we put this on the next item, next agenda, and we have regular agenda items, we're going to have a crunch if people show up next time. But I mean, I think the public has to speak its mind. I hope people submit it in writing, but the short answer to your question is we're going to have to leave it open for public comment and do the best we can. And Steve says we should try to make a decision on the 20th. We still have the 28th sitting there if we have to. And then Mike can walk into his office and stay here all night and write it up for the council the next morning. You know that. It won't be the first time. Go ahead.
As a second point, again, procedurally, while I spoke on my own behalf,
Yep.
I get to wear those two hats as a advocate for
Your client?
my clients
I guess.
or other clients. Would I be permitted to speak on their behalf, not voicing my own opinions again?
When you were speaking, you were referencing clients. Were you not speaking on your own behalf?
I was speaking on my behalf. They did not want to be identified tonight. They want to wait and see.
But you were
if they want to be-
speaking about legal clients, so.
Yes.
Were you speaking as a lawyer on behalf of legal clients, or were you speaking, because you identified yourself individually?
I did, because I
However,
was
you
asked to.
then spoke about clients.
Correct.
So at what capacity were you speaking when you were speaking about clients?
I believe also you spoke of clients and taking legal action.
That's correct.
Yes, so-
I have one set of clients. I may have another set of clients that want to be heard. That's why I wanted to know. And I would identify them and bring them with me.
Another 3 minutes, maybe?
Yeah, that's fine. I mean, we're not going to
Right.
split hairs here. I just, you
Yeah.
had come up
Yes,
as a resident, and then you started talking about clients.
I did. I mentioned my clients, and I was speaking on their behalf. I identified myself as a resident because I was asked to identify who I am and where I'm from.
So you're not Benedalia from Warwick, attorney, you're
That's
Benedalia
right.
from Narragansett.
Narragansett, and I happen to have clients that I was speaking on their behalf, Steve.
3 minutes is 3 minutes.
Yeah.
His clients,
You can come back for 3 minutes.
his clients, Mr. Chair.
Well, I might
his
come back
clients
and watch
can
the whole
speak for
thing, but
themselves.
I just wanted to know if I.
Well, they could speak, but also the attorney can speak for the client.
Oh, I
And you
agree.
can get another 3 minutes.
I'd
so.
rather hear
Yeah,
from
my-
the client.
if
Well,
I
that's up to them.
I will represent it. If I speak on behalf of my clients will not speak on their own behalf.
Right, thank you.
Limited.
Appreciate it. Okay, anything else? Yes, sir.
Just a clarification, you were referring earlier to the Judge Fortunato's decision in the Stefano v. Haxton case, and we read that thoroughly at the time we were preparing the ad hoc report, and it's been a number of years, so I'm doing this from, memory, but my recollection is that one of his findings against the town, one of the rationale he gave was that there was no proof that the ordinance would solve the problem, which is why I think the Providence case, he was sort of, scolded, because in the Providence case, I believe the Supreme Court concluded that there was no burden on the city to prove that it would work, just its belief that it was a reasonable thing to do. The other thing, my recollection of what's in the Fortunato decision is there's a comment in there somewhere, I believe, and I could be mistaken about this, but I don't think so, that the town at the time did not defend itself, that there was no defense from Narragansett at that time. So it was a long time ago, so
Okay.
we weren't here, but just wanted to.
I think, thank you, but I think it's old news now. We're moving forward. There's no reason. We've got 34 cities and towns that have an
Well,
unrelated.
the other thing, too, this is a zoning. Right, this comes in under the zoning. So
Yes.
this isn't, actually, it's not about students. The burden of this is on the homeowner, and the homeowner meeting the requirements of the zoning within the zone that they have a building in.
Yeah.
I mean, that's the bottom line.
I have a copy of that previous
Yeah.
case Mr.
Okay.
Schofield just mentioned, if anybody wants it.
Right.
I can send it out to you.
Thank you, John. Do you want to come up and identify yourself, sir? And you have 3 minutes to make a comment on this ordinance.
James Durkin, 375 Ocean Road. So I own Durkin Realty, and we rent to hundreds of students. I can say that we've probably gone through almost all of the houses this year, and something's different. Things are starting to, I don't know, I think between COVID, ordinances, the four-person thing, you don't see like the holes in the walls and that kind of thing. Most of the houses were left pretty good. Very few complaints from neighbors as far as our own houses go. I do think there's a problem with short-term rentals, not vacation rentals, but for short-term rentals. But everybody talks about this Providence case, and I went to Providence College. I was lucky to go there for 3.5 years, and I lived off campus my junior and senior year, and half of my freshman year. There was very seldom a house that was a single-family house that was available to students. Everything was at least 2 stories, like a duplex, or 3 stories. So if anybody's familiar with like Eaton Street or Oakland Ave or any of those streets that go around the campus,
Yep.
they were built to house students, I think, or maybe they were built to house manufacturing families or whatever back a long time ago on sometimes smaller lots than in Narragansett. Like, I would say they were like 40 feet wide because the house was like 20, 24, and then you'd have the driveway on the side and you'd have some kind of parking in the back. So I could see where Providence had a real problem there, because you could, when they passed that ordinance, they weren't really thinking about single-family dwellings. They were thinking about 3. So you can put 9 students legally still in a house in Providence, because most of them are 3-deckers anyway.
Okay.
And so that means they have to be able to park 9 cars. So a lot of those kids walk to campus because it's pretty close. So I think that ordinance really, although some people think that that is the avenue to bring down the students from the 4 to 3, I think eventually that's going to be kind of like, it's not going to be the same, you know? And it's just going to keep this whole legal thing going, which is a real nightmare.
Okay.
It's a nightmare to the people that want it. It's a nightmare to the council. It's a nightmare to these us business people. This stuff has to keep going on and on and on.
About 30 seconds, Mr. Durkin.
Yeah. So anyway, I guess I'm not for it.
Okay.
And I think, you know, when it was 4 and 4, when it was the 4 unrelated and the 4 student, you know, everybody was all right with that, but then some people had to go a little further with the 3 student, and I just don't think that fight is ever going to go away.
Okay,
Hopefully, you guys can see what's best for the town.
thank you.
Thanks.
Appreciate it. Okay, everybody's spoken who's in the room, I think, that wants to speak. So I think it's probably best to continue. You and I and Ms. Sabo will, yeah?
I'm sorry. This question's been haunting me. This question's been haunting me since I started going through this. Why is this 3 students to a house and not 1 student per bedroom? I just need to understand that.
Go ahead, Mike.
There have been, in recent past, one of the other contributing factors to some of the public outcry has been the recent development of some very large homes with lots of bedrooms. 8-bedroom houses, DeFelice Road. Those just come to mind, but there are plenty of others.
Yep.
So I think that's a trigger point. I don't think it's, I do have the numbers as to the number of houses in town that have 2, 3, 4, 5, 6, 7, all the way up to 10 bedrooms. And the number of properties up that exceed 5 bedrooms, it's actually in the report, that exceed 4 bedrooms, that are rentals, registered rentals, 363. That's as of 2020. I did not update my data. I don't think it's necessary because the point is well made, whether I'm off by 5 or 10. So 363 out of almost 10,000 dwellings, somewhere in the range of 2,500 rentals in town. But I do believe that the recent construction of large homes, which immediately went to rental, they weren't built for the Brady Bunch, you know. They were, no pun intended, Mark.
We would have a problem under these ordinances, the Brady Bunch. would.
Yeah. Anyway, point being,
Okay.
that's what was the trigger point. So limiting 1 student per bedroom does not address these large
Yep.
houses.
Right.
That's where I think it's coming from. I'm
Well,
not
that makes
a
sense.
proponent of it, I'm just telling
That
you
makes sense.
Nope.
what I've observed.
I just think that needed to be put out there.
Okay. So let's, I'll get with Ms. Sabo and Mr. DeLuca on the regular agenda. We'll see what we can figure out needs to be done, but we'll continue this until that time. We'll leave the public session open. People can submit in writing, and we'll go from there.
Do you need a motion to continue?
Yeah, I think
I
we
do. January, what's the month line? June 20th.
So make a motion to continue to June 20th?
Seconded. Third.
It's a motion by Mr. Friday, second by Mr. Brady. All those in favor? Aye.
Aye.
4-0, and a motion to adjourn.
So moved.
Seconded, non-debatable.
Motion